I'm the owner and principal attorney of Mortimer Legal, PLLC, which is primarily a trademark law practice. I'm also a children's book author and co-owner of an independent publishing company, and I typically work with small to mid-sized businesses, solopreneurs, authors, podcasters, and other content creators. So, it seems more and more people are becoming aware of the importance of intellectual property and the role it plays in protecting your business. I encounter many people who claim that they need to register a trademark or really don't know what it means. So let's start at the beginning with the definition. What is a trademark? It's the protection of a brand as the source of goods or services. It's how customers recognize you in the marketplace and distinguish your brand from those of your competitors. So, trademarks, let's see, what are they? A trademark can be a word. It could be a phrase such as a slogan or a tagline. It could be a symbol. It could be a design, which is your logo, or it could be a combination of these things. Trademarks can also include sounds, like the Netflix intro sound, colors, think of Tiffany's and its trademark shade of blue, and even smells. Believe it or not, the smell of Play-Doh is even trademarked by Mattel. So here are some typical ones that I'm sure you all are familiar with. We have the BMW symbol, we have Taco Bell, Apple, Google, Coca-Cola, America runs on Dunkin'. These are all trademarks, phrases and logos that each call to mind the reputation of the particular goods or services that's associated with it. The important part to understand is that whatever it is you are seeking to trademark, it must be used as a brand. What does that mean? What is a brand? A brand is a source identifier. It indicates the source of a good, which could be physical or digital, and or a service. Simply put, your brand has to be connected to goods or services that you offer and or sell. Additionally, your brand must be used in commerce, meaning it is consumer facing. I'm going to go into that a little bit, consumer facing. So let's say your business is ABC LLC, but you're doing business as DEF. If DEF is the brand that everyone sees and that's consumer facing, that would be the brand that you would trademark, not ABC LLC, because it's not consumer facing. So therefore it's not a brand. And so it has to be consumer facing and it has to be used in interstate commerce as well, meaning it's used across state lines, which is a requirement if you want national trademark registration. So let's look at our first common trademark misconception. We're going to go through a few of them. Simply using the TM or SM symbol behind your brand protects you. False. This is one that I see often. And for clarity, TM means trademark, SM means service mark, it pertains to services. So there are 3 different types of trademark protection, 2 that require registration and 1 that doesn't. Let's take a look at them. We have federal trademark registration, which means it's registration with the United States Patent and Trademark Office. You get nationwide protection to all 50 states and its territories. You must have continuous use in commerce and interstate commerce, and it's represented by the circle R. Then you have state trademark registration. That's registration with the Secretary of State that your business is located and does business in, and it offers statewide protection. You must have continuous use in commerce within the state, and TM or SM is used. State trademark registration is more appropriate for those businesses that don't operate or do any business outside of their state. For example, a nail salon or maybe a childcare center. These are businesses that typically only operate in one state and service clients within that state only. However, if these businesses were seeking to franchise outside of their state, it would be wise to seek federal registration instead. Now we have common law. A lot of people don't know about that. So common law requires no registration, so it's cost effective, right? But your protection is limited to the geographic area in which the mark is used, and you must have continuous use or you will lose protection. Common law rights offer very little protection and can be time consuming and costly to prove. Today, we're going to focus just on federal trademark registration. So, When is the TM and SM used? Well, the use of the TM or SM behind your brand can be used to, one, inform the public that you intend to file a trademark application, federal trademark application, you have filed a federal trademark application, or that maybe you have a state registered trademark, which again means that your brand is only protected within the state it operates in. But most often, people operate under the misconception that by using the TM or SM symbol, they are federally protected from infringement. This, again, is not true. The only symbol of federal trademark protection is the circle R, which is only obtained through trademark registration with the United States Patent and Trademark Office. And using the circle R, if you do not have a registered trademark, is considered fraud. So how is a trademark different from a patent or a copyright? Because I often see that this is a source of confusion in differentiating trademarks from other forms of intellectual property. Let's take a look. Patents is a protection in an invention, design, or process that provides a new way of doing something or offers new technical solutions to a problem. Think the telephone, the light bulb, a security system, Amazon one-click ordering system. These are all processes that have been patented. Now, copyright is protection of work that has been affixed to a tangible form of expression, like a book or a recording. Copyrights are created the moment you write the idea down or create the video. However, to file an infringement claim, you must register it with the U.S. Copyright Office. The so-called poor man's copyright mailing, something to yourself is a myth and not legally recognized, but I digress. We're all talking about, this is about trademarks. Trademark is all about brand distinction and protection. So while patents protect inventions, copyrights protect original works, trademark is all about brands. Trademark protection is about distinguishing your brand from your competitors to establish a brand identity and can contribute to customer loyalty. Having a strong trademark can be an important part of building a successful business foundation and protecting the integrity and reputation of your brand. But why should you care? So most people seek trademark registration for the simple reason that they do not want someone else to infringe on their brand. While this is a reason, it's not the number one reason. The number one reason should be to ensure that you're not infringing on someone else's established brand. Regardless of whether another brand is a federally registered trademark, if that brand's use precedes or predates yours and has been consistently used, then the owners of that brand have certain rights. Your infringement on those rights could result in costly lawsuits or a forced rebranding. This is where state and common law trademark rights can come into play and affect your use of a mark. And I'm going to use the word brand and mark interchangeably, but they mean the same thing. Number two, once it's established that you're not infringing on an already established brand, then your concern should turn to enforcing your brand against would-be infringers. So U.S. registered trademark owners have a legal obligation to protect their trademark and take action against anyone who infringes on their trademark rights. This is to maintain the exclusivity of your trademark, prevent confusion in the marketplace, and maintain the integrity of the whole trademark system. Why else should you care? Well, number three, like tangible property, registered trademarks can be bought and sold, bequeathed in a will, or placed in a trust. Just like you would tangible property, a well-established trademark builds value and can be a valuable asset to sell or hand down. Think legacy building when you're building up your business. Finally, number four, it's a valuable business asset that can be leveraged in licensing agreements or other commercial agreements. In some cases, a trademark may also be licensed to another party for use in exchange for royalties or other compensation, such as licensing your brand to sell your products in major department stores, or if you want to franchise your business and license your trademark to franchisees. Overall, owning a registered trademark can provide significant value and benefits for a business or individual. Here's another common misconception. Business formation equals trademark protection. False. So, okay, I have relatives whom I advised that they should trademark their brand tell me that when they formed their LLC, they did a search and there was no other business that had their brand name. They thought that since they were cleared to form the LLC, that meant no other business with that name existed and they were protected. They were really surprised when I told them it doesn't work that way. The secretaries of states of all 50 states, they don't speak to each other. So, though they were cleared to form the business entity in their state, that doesn't mean that the same business can't exist elsewhere. So let's say your business is Acme Bakery. Theoretically, there can be an Acme Bakery LLC in all 50 states. So clearance to form a business entity within your state does not mean that the same or similar business name can't exist in other states. So business formation offers absolutely no trademark protection. The only way to obtain national trademark protection is by filing an application with the United States Patent and Trademark Office. The Secretary of State does not count. Likewise with domain ownership. Domain ownership equals trademark protection? No, simply not true. So you go to something like GoDaddy and you purchase the domain acmebakery.com. Ownership of the domain does not mean that you are trademark protected. Theoretically, you could have acmebakery.net, .org, .us. Ownership of a domain does not protect you. Again, the only true way to obtain federal trademark protection is through filing with the USPTO. Here's another common trademark misconception. Trademark registration gives you exclusive ownership and use of the mark. False. Another common misconception is that when your trademark is registered, you have the exclusive right to use your trademark and no one, no matter what they sell, can use it. Wrong. When you file a trademark application, you have the option to file in one or more of the 45 classes or categories of goods and services. So when you seek trademark registration, you are only seeking protection in the class or classes of goods and services you choose. And if your trademark is actually registered, you're only protected within the class of goods and services that were actually approved and registered. Let's take a look at a tale of two brands. So, a perfect example of the non-exclusivity of trademarks is the brand Dove. There are two different registered trademarks for Dove, owned by two different companies. One is registered for the class of goods and services that pertains to food, and the other one is in the class of goods and services that pertains to soap products. The rationale is that each caters to a different market, each with its own consumer channel. So consumers shopping for Dove soap know the difference between Dove soap and Dove chocolate, and there isn't any confusion. Another misconception. You own, quote unquote, your trademark the moment your application is filed. False. This is one that I have seen numerous times on social media. Someone has filed an application and now they claim that they own the trademark and have exclusive rights to it. And from the comments that I read on posts like this is a very common misconception that's simply not true. When you file a trademark application, that's it. It's just an application. It can still get rejected, withdrawn, or be abandoned. And the reality is that of the average 2,000 applications filed daily, most are. When you file a trademark application, it still has to go through the entire process of being reviewed by an examining attorney, publicized for possible challenges, all of which can take a year or more. So you do not own a trademark until you have fully completed the process and the mark is registered. And so remember, registration is only for the class of goods and services that you applied for and that were approved. So what is the trademark process? Let's take a look at it. So you have, after you file the application, it then has to do the comprehensive search first, actually, and then you file your application. And then you wait, pretty long wait, till it gets assigned to an examining attorney, then it gets publicized, and then it goes to registration. So the process seems like it's pretty straightforward, right? But it's not, and it can be pretty complicated, and depending on how distinct your brand is and how skilled you are in the process, it can be hard. So let's look at it step by step. Step one, the search. It's a good idea to conduct a trademark search before submitting your application to make sure the same mark isn't already on the register and there aren't any similar trademarks already registered, pending, or in use that could cause confusion with your mark. This is called clearing the mark. So let me emphasize that the standard for trademark registration is not whether a mark is identical to any other mark. The standard the examiner will apply to your application is whether your mark is the same or similar, offering or selling the same or similar goods or services as any other registered trademark or pending application in the USPTO database. While simply searching the USPTO database using the trademark electronic search system may feel like it is sufficient, this basic search has its limitations, which really boils down to your search skills and knowledge to find any and all possible conflicts. So let's say that you were opening, let's give you an example. Let's say that you were opening a coffee shop and you wanted to call it Starbucks with 2 S's. You search the USPTO database, tax, and you don't find a mark with that name registered or pending. So you think that it's clear. It's clear to register, good to go. However, not only would you receive an immediate rejection from the examiner that it's a conflict with famous brand Starbucks with 1 S, but Starbucks would certainly send you a cease and desist letter and then you may be in legal hot water. So for this reason, it's suggested that an attorney conduct a more thorough search using a proprietary search system to find a much wider possibility of conflicts and then review the results. This is the comprehensive search. So in addition to the USPTO database, the attorney is also going to do a more comprehensive search of state trademarks and possible common law trademarks that exist by looking at business filings with all the secretaries of states, domain names, and even social media handles. This information is important because it could be problematic to your application at a later stage that we will discuss.
I have a question.
I was going to ask if you can hold on to your questions until the end because I may answer it with what's coming up. Sure. Okay, so now we have the application. So once the mark is clear, the application can now be filed, right? So what are we looking for? What are the trademark application filing requirements? Well, number 1, your filing is either a standard character or a design mark. So the standard character covers just the words or the phrase of your mark, and it's regardless of the font, style, size, or color, so it gives you a wider latitude of how you can use it. Or you can file as a design mark, which is like a stylized logo, which covers the specific design elements of your mark. Number 2, like I said before, the application can be filed in 1 or more of 45 classes of goods and services. You can file in theoretically all 45, but you must file in 1. There must be a clear description of the goods and services that are offered in each class, and the description must correspond with the correct class. That's important. You must provide the first date that the mark was used in commerce and interstate commerce. This is for registration. And for registration, you must provide a specimen showing proof that the mark is being used in each of the applied for classes. Finally, there is the non-refundable application fee, which ranges from $250 to $350 per class, with the cheaper fee having certain limitations. Common trademark misconception. Your business must be operational and you must be using your brand in order to file a trademark application. Not true. You don't need to form a business entity, have an active business, or have a brand in use in order to file a trademark application. You can simply just have an idea. When I speak to aspiring entrepreneurs, some are shocked when I tell them this. That's why the best time to contact a trademark attorney or go through this whole process is at the very beginning of your endeavor, when you just have an idea for a brand and its intended use. That way, the mark can be cleared before you file and spend time and money developing the brand. Now, let's look at 2 different types of applications, because it's important to note that there are 2 different types of trademark applications. One is for brands that are currently being used in commerce. That is the 1A in-use application. The other is the 1B intent to use application, where, like I said before, you have an idea for a brand and you know exactly what you want to use it for, but you're not using it yet. In this case, you can still file a trademark application that gives you the benefit of a priority filing date, and then it gives you time to develop the brand. So let's say you file an intent to use application for Acme Bakery, and someone files an application after you for something like Acme Baked Goods, selling the same or similar products. Since you filed your application, since they filed their application after you, their application will be suspended pending the registration of your application. That's what the 1B. Well, sorry, let's go back. Now there's a caveat to that. You have to have a bona fide intention to use the brand in commerce. Someone can't just file an application simply because they don't want someone else to use a particular mark. I've seen that done before. An application cannot proceed to registration until actual proof is shown that the brand is being used in commerce and interstate commerce in the classes it was applied for. So you can't just take up space in the register. And with current processing times, you will have about a year and a half after your application when you'll be required to show that proof. But you must show proof in order to be eligible for registration. So it's important to note that filing for a trademark is really just the beginning of the process. After you receive your filing receipt and you think that that's it. Well, guess what? The long wait begins. The USPTO is reporting times as long as 9 to 10 months before your application is assigned and seen by an examining attorney. So think about it. An entire baby can be formed and born by the time your application is even looked at. But let's skip ahead now 9, 10 months, and your application has now been assigned to an examining attorney. The examining attorney determines whether your application meets all the legal requirements for registration. So what does the examiner look for? Well, first and foremost, they're going to look to see whether your mark is distinctive. That's the number one. And in determining distinctiveness, the question really is, how strong is your mark? As this chart indicates, the strongest marks are offered the most protection and are the least problematic to register. With, again, more than 2,000 applications filed daily, you want to make sure that your brand is as distinct as possible. So let's take a look at it. The strongest are your fanciful marks. These are words that are completely made up, like Pepsi, Exxon, Pfizer, and that has built up recognition in the marketplace. Then you have the arbitrary marks like Apple, Coach, and Camel. They actually just have nothing to do with the goods or services associated with it. So it would be problematic if Apple was for actually selling apples, but Apple's for computers, Coach is for leather goods, Camel is for cigarettes. So they have absolutely nothing to do with the brand the goods or services that they're associated with it. Then you have suggestive, like Netflix, Coppertone, Microsoft. They all hint at the goods or services associated with it. Netflix is a really clever combination of internet and Netflix. Then you're getting to the least descriptive. These are the weaker brands, the descriptive ones. Sandwich Shop, Florida Health Club. They simply describe the goods and services. It's not to say that they can't be registered, but they have a harder hill to climb because they have to show that there's some sort of notoriety or recognition in the marketplace for them to be registered. Then you have generic, which is the actual name of the product or service, and it's so overused that the word is synonymous with the product or services. These offer no protection at all. Q-tip, Band-Aid, aspirin, these were all once registered trademarks, but because they've been what's called genericized, they have lost their trademark protection. So what else does the examiner look for? Well, does the mark function as a trademark? Marks that fail to serve as a source identifier for goods and or services will be rejected. If your mark does not function as a brand, if it's not identified as a source of it, then it's not going to work. A perfect example of that is clothing, actually. If you have your mark and it's just solely on the front of a T-shirt, that would be considered merely descriptive. It doesn't serve as a source identifier of the actual brand of the company that is actually selling or manufacturing the T-shirts. The next question is, do the classes and descriptions of goods and services correspond correctly? So if you have filed for Class 3, is the description for goods and services that are located within Class 3, or is that for Class 25? They have to correspond. Now, does the specimen show appropriate use of the mark in each of the applied for classes of goods and services? If your specimen that you're offering does not show the use of the mark in that particular class, it's going to get rejected. So it has to be appropriate. Now, does the mark conflict with any active registered trademark or pending application? This is what's called the dreaded 2D likelihood of confusion that can happen with a lot of trademarks. And this is most important if you have not done your comprehensive search first. So let's look at it. Remember, the standard is not the same, but is it the same or similar? And let me tell you, what can be considered similar is pretty broad. It can be similarities between, well, it's two-pronged. They're looking at the similarities between the compared marks and the relatedness of the compared goods or services. Similarities in the compared marks is pretty broad. It can be similarity in sound, appearance, connotation, and overall commercial impression. So let's look at sound. Acme Bakery and Acme Bakery. Acme is spelled differently in both, but they sound the same. That could be considered commercially confusing to the average consumer. Appearance, Acme Bakery and Athens Bakery, but they're written in the same font. They have kind of a similar design. So would the average consumer be confused by those two? Connotation, Acme Cakes versus Acme Pasteles. Believe it or not, foreign languages are taken into consideration. Though cakes and pasteles are two different words, pasteles means cakes in Spanish. So that would be considered similar. Then they're looking at just the overall commercial impression. Acme Bakery versus Acme Baked Goods. Well, baked goods has kind of like the same connotation as bakery. They both begin with the words Acme. They're both in the same font. Would the average consumer look at those two and be confused? That's the question. If the examiner says that that's a possibility, then you have to defend and say, no, it's not. Well, okay, let's say that they determined that there's a similarity between the two brands in their appearance. Well, now the second prong is they're related in the compared goods and services. So similar, t-shirts and pants versus hats. They're in the same class. Is the same place where a consumer buys t-shirts and pants the same place where they buy hats? I don't know. Banking services versus mortgage lending. They're both in the financial. They could be both in the same class. Are they commercially related? Hair shampoo versus body soaps and wash. Are the same place where a consumer is buying the hair shampoo? Is it right next to where they're buying the body wash? That could be a problem. Are they traveling in the same trade channels? Clothing apparel versus an online retail store selling clothing apparel. Those are two different classes. Clothing apparel is class 25, online retail store is class 35. But the thought process is that if you're buying clothes on an online store, it's still the same kind of trade channel. It's the same place that you're buying it from. And would the average consumer be confused if you have Acme clothing store and Acme t-shirts? Would there be a false sense of association? Would an average consumer be confused? So this is what they're looking for when they're looking to see whether a mark conflicts with another mark. And if there are any issues with your application, such as the 2D likelihood of confusion, you're going to be issued, the examiner will likely issue you an office action. We'll start with the non-final office action, which is an official letter outlining the reasons why your application has been rejected or needs to be amended. So it used to be 6 months. Now it's 3 months that you have to respond or request an extension, which gives you an additional 3 months. They want you to pay more. And you have two different types of office actions. You have your procedural, which just deals with technical issues with your application, like missing or complete information dealing with ownership, your address, or maybe even in the description of goods and services. But then you have the substantive, and this deals with the actual eligibility or registrability of the trademark itself. A response usually requires an attorney to draft a legal memorandum with persuasive arguments supported by evidence and case law. This is where that 2D likelihood of confusion would fall. That would be considered a substantive office action. So you must respond to all office actions on your application, or it will be marked abandoned. That means you have to file, again, within the 3 months, either a response or a request for an extension. And applications will only proceed to the next stage if you're able to overcome all examiner refusal. You can have one office action and it has multiple things that are wrong with it. Some of it are procedural, some of it are substantive. And If you have not dealt with all of it, you're not going to be able to go on to the next stage. Maybe if you deal with just some of them, but some of the other things the examiner is not satisfied with, then you'll get issued a final office action given another 3 months to respond by either a response or a request for an extension. So if you're fortunate to make it past the examiner without any issues or conflicts found, or you were able to overcome all issues, your application will proceed to the publication phase, which may be your last hurdle before registration if you filed an in-use application. So what is it? During this period, your trademark will be published in the USPTO's Trademark Official Gazette for opposition. This means that any party, regardless of whether they have a registered trademark or pending application, can challenge your application as long as they have a legitimate belief that their brand may be damaged by your mark's registration. They can file either an opposition to registration or request an time to extend to their opposition. Oppositions are handled by the Trademark Trial and Appeal Board, which is basically the court of the USPTO. Now, this is where searching for state trademarks and common law marks can come into play because any of those can oppose your application. Remember, they don't have to have a registered mark or a pending application to oppose. So it's important to note here that the US uses the first to use, not the first to apply trademark system. In the first to use system, the user that can demonstrate the earliest continuous use of a trademark in business usually holds the rights. That goes back to why it's important to conduct a thorough and comprehensive search, including state trademarks and businesses with possible common law rights, before filing your application or using your brand. Even if there isn't a competing registered or pending trademark application in the USPTO database, there may still be brands protected by state or common law rights. If these brands can demonstrate prior and continuous use of their mark, they can challenge your application and possibly win. So, no opposition has been filed. Before that, you will overcome all of your any refusals by the examiner. Your mark will be registered in 8 to 10 weeks and you will receive a registration certificate. This entire process can take at least 15 months, much more if you file an intent to use application. After the publication, if you did file an intent to use application after the publication period, that's when you would be issued a notice of allowance, and you would then have to file proof of use with your specimens at that point, and then you would proceed to registration. So let's look at another common trademark misconception. Once your trademark is registered, nothing else needs to be done. I've seen people lose their trademarks over this. False, another big one. You've gone through the entire process of doing your search, filing your application, overcoming any challenges, and you've gotten your trademark registered, but that's not the end. A lot of people think that that is, and they now have a trademark that they own forever, but it's really just the beginning. There's maintenance. Registered trademarks must be monitored and maintained. So what are the duties of a registered trademark owner? Remember, there's a duty that trademark owners have not only to police their trademark from infringers, but they must maintain it. So within years 5 and 6, after your trademark has been registered, you have to file renewal documents showing proof that you are still using the brand in commerce. Then you have to do that again between years 9 and 10 and every 10 years thereafter. If you fail to file renewal documents, your trademark will be canceled. And if it is canceled, that means it's free for someone else to register. Think about it this way. The oldest actively registered trademark was registered back in 1884. It's still active today. So it's really important that after your trademark has been registered, that it's maintained. Not to mention that continuous use of the registered trademark symbol on a brand that's not or no longer a registered trademark, remember I said before, is considered fraud. It can be legal hot water. Now here's another common misconception. You don't need an attorney to file and handle your trademark application. Well, that's partially true. While an attorney is not required to file a trademark application with the USPTO, there are many reasons why seeking the help of an attorney can save you time and money in the long run. First, the skilled attorney can significantly increase your chances of securing trademark registration than if you were to file it on your own. Studies show your application has a 60% greater chance of receiving the registration with the help of an attorney, and that statistic has stayed consistent. So let's look at how an attorney can help. An attorney can tell you whether your brand is eligible for trademark registration, first of all. As you've seen, not all brands are eligible for registration. Marks that are generic or that are merely just describe the goods and services you offer may not be eligible, and some marks don't even function as a trademark. An attorney can also conduct a thorough, comprehensive search to minimize the risks of USPTO office action refusals, provide legal opinions on the possible risks and challenges to your application, and provide appropriate strategies, expertly draft a description of goods and services that are likely to be registered, and advise you on proper specimens needed to prove use, as well as evaluate your business and make suggestions of all the classes you can file in that would protect your brand all around. An attorney can also handle all communications with the USPTO and monitor your application. They can respond to all office actions, whether the issue is minor or major. I have seen so many applications that were abandoned for an issue that the applicant seems major, but they were such a simple fix. And also, responding to substantive or major refusals like that to the likelihood of confusion can be difficult and quite costly. While an attorney can help respond to these challenges, they can also help minimize the risks by doing that also important comprehensive search in the beginning. And that's it. That's the entire process.